We actually have a call tonight. Let's go ahead, caller. Go ahead and tell us what's going on. This is from Dance. What's up, Dance?
Yes, I would like to know if a will or a revocable trust, which one is better?
What depends on what the situation is that you're asking about. Really, when you're talking about a will or revocable trust, you're talking about two different instruments. A will is typically a declaration once you die, your property is going to be divided to your heirs, or really whoever you want, in percentages or portions as you set forth when you're still alive. So let's say you have several grandkids and you've got a wife and you've got your regular kids, and you want to say, well, I want to give this much to this person, that much to this person, I'm going to give my wife this much. You can do that through a will. A trust is a different situation, and full disclosure here, this is completely outside of our area of practice. I have to think back when I was in law school and we talked about wills and trusts, but essentially a trust is an instrument that provides think of it as like a legal ownership of assets, that then those assets are then used and managed by a trustee for the benefit of the beneficiaries of the trust. And so it's not uncommon if you say you have some property, you have a house, you have condominium, you have different assets, you want to put those into a trust, have it managed for the benefit of people that you want to name as a beneficiary. And so the legal title to that property doesn't actually go to them, but it is a benefit to them. And a revocable trust is simply exactly what it says. It's a trust that you can revoke. It's not something that goes in perpetuity. And in fact, there's a rule against perpetuities that they teach us in law school that I don't even remember. I just remember it had something to do with 99 years.
But the other thing is with a trust is a trustee is going to manage those assets. So let's say you don't want to give your kids $1 million after you pass or something like that. If you have it in a trust, you can have a trustee manage it and whether make payments or do things like that. It's asset planning. It's really, for those situations, always contact an attorney who actually does estate planning, and they can figure out what instruments are best, and you can modify deeds. So it's the ownership transfers without going through probate or doing anything like that.
Right, yeah, that's something, if you've ever heard the term a ladybird deed, that's a situation where you can actually name somebody as a beneficiary of a property without it actually changing ownership. But definitely that's a situation you want to talk with an attorney that handles those types of things. There's some very good attorneys here in town that handle wills, trusts, estate planning. And if you don't know who to go to, I mean, people call us all the time with recommendations, even with cases that we don't take. If somebody calls us and says, hey, I'm looking for a criminal defense lawyer or somebody to help me with estate planning, or I need somebody that can help me guide in some elder law issues. Maybe they have an older family member that they're wanting to make sure they're taken care of. There's several attorneys here in town, and if you don't know who to call, you can always give us a call. We can steer you in the right direction.
And it's better to do it sooner rather than later.
Do it sooner rather than later, yes.
If you are, and again, we're all eventually going to pass, but it's better to do it even now. I'm 37 years old. It's better to know where your assets are going. So in the event we deal with accidents all the time, things happen. You know your assets are going where you want it, as opposed to putting it off until the last minute.
Yeah, the other thing about pre-planning something like that is as you get older, sometimes memories start to fade, sometimes your cognitive abilities slip a little bit, and at some point, God forbid you end up in a situation, you've got a loved one that can't think clearly, doesn't really have the capacity to make decisions. At that point, it may be too late for them to do anything, because whether you're doing a will, whether you're doing a trust, a power of attorney, a healthcare surrogate, you have to be, if you're the one that's going to be granting those powers to somebody, you have to be of sound mind in order to make those sorts of things. Somebody that has been declared incompetent, or that they suffer from certain illnesses, dementia, Alzheimer's, things like that. Once they get to a point to where they cannot make those decisions, then you run the risk of one of those instruments being invalid because the person making it didn't have the capacity to make those decisions in the first place. And so it's really important, if you're thinking about it right now and I've got this property, I've got this family, I want to make sure my grandkids are taken care of, go ahead and talk to somebody right now while you still got your wits about you, and you can make that decision as a family. And that always works out a lot better if you pre-plan those sorts of things than trying to do it at the last minute. You don't want to be reactionary in that sort of a situation. You want to be proactive. So, Dance, I really appreciate the call. Great question.